All right, well, good morning, everybody. Welcome to week 3 of class. We're going to be going over, excuse me, we're going to be going over evidence and hearsay today, as well as some exhibits and a few other things, especially with how it relates to your mock trial. We're going to have an announcement or two, and then we're going to go ahead and start going with class. So with that, I'll turn it over to Patrick.
Good morning, everyone. As you know, you guys probably already started contacting your partners for the mock trial. We have had a few of you guys, a few individuals that dropped out. So I will be sending out a final list on Monday. So if you reached out to your individuals and they have responded, then there will be no changes. Well, let me take that back. There shouldn't be no changes. However, if you responded to somebody, if you reached out to somebody and they have not reached back, it's probably because they dropped out of the program. So what's going to happen is I'm going to have to reshuffle the list. You guys will still be in the same groups and group sets. However, you might have to go twice. So I will let you guys know individually who are the individuals that will go twice. It's pretty much whatever your first presentation is, it's going to be your second presentation. Just meaning that we don't want you to change anything. We just want you to just give it the second time so your other colleagues, your other partners, participants will be able to participate since some people dropped out of the program. If you guys have any questions, just go ahead and email Katya or myself. But on Monday, you guys will get the final list. We're pretty sure now that we're already halfway through the program, more than halfway through the program, and the individuals who've been participating will be at the mock trial. So we don't believe that anybody else is going to drop out between now and then. But other than that, the mock trial is in 1 week. So we want to make sure you guys are contacting your, once you get that final list, contact them as soon as Monday. As soon as you guys get that, contact your partners, okay? If you guys have any questions on how to prepare your case, Mike is going to be there and the other folks will be there to help you guys as well on Discord, okay? Good luck, and we're only 2 weeks away from, well, 1 week. This is the 1 week away, 9 more days, and we're going to start our mock trials. All righty. But once again, you guys will be in the same group, same subgroup, but you might have to just go twice. All right. Thanks a lot.
And I'll add on to that. Don't worry about if you have to go twice or if you're running with some different people in case that happens. You're all doing the same trial problem. And if you've prepped a certain way, either questions or witnesses or however you want, so however you have to perform essentially, just like Patrick said, do what you're going to do, because the other side, that's kind of part of the law. Sometimes you don't know what your witness is going to say. Sometimes the questions you ask don't get answered the way you want them to be asked. Your own team that you've been working with may do that. You may have practiced a certain way, but then you get into the actual mock trial and what's said is different. That's not a bad thing. That actually happens in real life. I have prepped witnesses for weeks, and then I get them on the stand and they answer things completely different. So that's how the law works. So don't worry about it if things are a little different. So because that's good practice for you for regular trials and everything. Felipe, I would immediately contact Katya or Patrick regarding that. The earlier we get that information, the better. We can reach out to those people to see if they're still involved in the program and reassign as necessary. I do have one question for Patrick or Katya. If you guys could please send me that list of people that are no longer in the program so I can remove them from our Trial by Peers Discord, I'd appreciate it. So with that, we're going to go ahead and get going. I'm sure you guys remember me from orientation in the first week. My name is Mike. I am a deputy district attorney in the juvenile division. Unfortunately, my partner in crime could not be here today. He had some other issues going on, so it's just, you just get to deal with me today, for good or for better or for worse. So we're going to go over, excuse me, we're going to go over some of the, we're just going to kind of briefly go over the outline for the evidence class, and we're going to start applying that to the trial. And I'm going to have you guys interact a little bit more than the first week. I don't know how much interacting you guys did the second week, but get some water, be prepared to talk today, because this is going to be a little bit more interactive. So is next week, because this is when we're really going to get into the meat of our trial. I saw someone asked about the trials. Yes, they are on Zoom. Everything will be on Zoom. Unfortunately, due to COVID and residual COVID stuff, we were unable to secure a physical location. So everything will be done on, the entire course will be done online this year. Hopefully, relatively soon, we can actually have something in person, and we'll let everybody know what that is when we get there, when everyone's ready to do that. But unfortunately, the whole course and the mock trials are going to be done on Zoom. So, all right. So unless anybody has any overall questions, we'll go ahead and get going with evidence and hearsay.
Mike, I just want to announce attendance today is going to be taken at the end of class. You don't have to put your name on the chat. I will take down attendance based on your name. So yeah, at the end of class.
Okay, sounds good. So, all right. So, who wants to tell me what evidence is? You can unmute. Somebody wants to unmute their mic and they can tell me what their idea of evidence is.
Something that proves or disproves the fact of the case.
Okay, so something that proves or disproves the fact of the case. Kaiden, I'm going to stick with you for a second. Is evidence a fact, or is it something that supports a fact?
It can be both circumstantial or direct.
Did you say it can or cannot be both?
It can be circumstantial and direct.
That's correct. Well, no. So I'm sorry. So you're half right and you're half wrong. So it can be both an actual fact or a suggestion of a fact, but evidence can either be circumstantial or direct. We'll get to that later. So you can go ahead and mute your mic, Kaiden. Good job. So Kaiden is correct. Evidence is something that will support it'll support your overall theory. And what you want to do is you want to get enough pieces of evidence to support your case. That is how you win trials. But not only just trials. If you have enough facts, you can talk to your opposing counsel and say, listen, I have these 9 pieces of evidence, and that's what I'm putting on in my case. And this evidence is so overwhelming, I don't think you have enough evidence to beat my case. So you might not want to go to trial. So it's very important to prepare your evidence and research your case and do all the work beforehand, because that might not even require you to go to trial. So Katya, I'm showing your hand raised. I don't know if that was on purpose or not.
Sorry.
That's okay. All right, so Kaiden was correct. There's 2 types of evidence. There's circumstantial evidence and there's direct evidence. So we're going to start with direct evidence. Who wants to tell me what direct evidence is and give me an example? Okay, it looks like Samuel unmuted his mic. Samuel, what's direct evidence?
Direct evidence is something that has been directly witnessed or proven to be true.
Okay.
A good example of this would be video evidence of someone robbing a bank.
Okay, that's good. That's a good example. I saw Tyler raise his hand in the chat here. So thank you, Samuel. Tyler, why don't you go ahead and unmute your mic? Do you want to tell me what circumstantial evidence is and give me an example?
Yeah, circumstantial evidence is evidence that you can more use to figure out a situation. It's not necessarily something direct and something that's completely seen. It's something more you can assume with what you have. An example can maybe be like, now I gotta think of an example. Give me a second. Can I have a second to think of an example?
You can take 5 seconds. How about that?
5 seconds. Okay.
You can take as many seconds as you do.
Actually, no, I'm just going to use the example that it says on the thingy. It says, if you go to bed and there's no snow on the ground, it is circumstantial evidence that it snowed while you were asleep. However, there's no direct witness to it snowing.
All right. Well, cool. That's good. But now I'm going to test you guys. I have here, this is to show you how old I am. This is my PlayStation 1 copy of Final Fantasy Origins. All right. So I'm going to give you guys a little fact pattern. I am the only person sitting in this room. And you're watching me right now. There's nobody in the room. There's no one behind me. My kittens aren't here. There's no Lexi, no Felicia, no Judge Sullivan. So I am playing with my CD case because I want to put the CD in. And all of a sudden I do this and I break the CD case. Is that direct evidence or circumstantial evidence of me damaging the CD case? Samuel, you can go ahead and take this one. And then Mackenzie, you're going to have the next one.
It's direct evidence because we watched you do it.
Okay. Now, that's correct. Now, I'll throw you guys another example, and Mackenzie's going to answer unless she doesn't want to. So, same CD case. Now, I picked this CD case up out of nowhere, and as I went to go open it, it fell apart. Is that circumstantial evidence or direct evidence that I broke the CD case? Mackenzie, you answered before on the direct. Do you want to answer this one, or would you like someone else to?
I'm not sure, but I think it would be circumstantial because you assume that because nobody else is in the room and because you picked it up that you probably broke it.
Okay, that's the correct answer. Now, I'm going to stay with you for a second, Mackenzie, because we're going to go into a little bit further ahead. We'll come back to it. Now, how strong, what's the weight of that evidence? How strong do you think that evidence is?
I don't think it would be very strong because somebody else could have been in the room before you and broken it maybe and then just put it back or like maybe glued it, but they didn't glue it right or something along those lines.
That's correct. So while it is circumstantial evidence that I could have done it, you need more pieces of circumstantial evidence to prove that. Now, I can tell you why I did break this because I'm a klutz and I accidentally stepped on it. So I admitted the crime. I'd like to settle. So whoever my defense attorney is, please go talk to the prosecution. I do not want to go to trial. Although I don't know why it's still in as good a shape as it is because I've had it for like 15 years, but that's another story. So those are perfectly good examples of circumstantial and direct evidence. Does somebody want to tell me what's better, direct or circumstantial evidence? Daniel, I see your hands raised. Go ahead and unmute your mic.
I think that direct evidence is better because it's more true than like circumstantial.
Okay, why do you mean by more true?
Like there's a bigger chance that it's like correct.
Okay, do you think direct evidence only needs to be exactly of the specific crime, or can it just be other facts that support that thought?
I mean, it can be both.
Correct. Okay. I see Felipe's got his hand raised. Felipe, why don't you tell me what your theory is?
I think the word that Daniel is looking for would be that direct evidence is more reliable and it has that weight behind it, that because it has more of that supporting evidence, then it makes it more reliable and trustworthy in trial.
Okay. It's a good explanation. We're going to get into it more, and then we'll take one more. Jana, I see Jana, you got your hand raised. Jana, what do you think?
I don't think one is better than the other. I think they both have separate uses, and I think both of them can be really helpful in court. It's just a matter of of how relevant and reliable they are.
Okay. All right. We'll take one more because I see Caleb raised his hand. Caleb, why don't you tell me what you think?
About the direct evidence.
Just what do you think? What do you think's more reliable?
Definitely direct, because circumstantial, like you said, it depends on circumstances. Like going back to the snow example, you see, you know, snow prints leading to a shed in the snow, whatever. You can conclude, okay, someone went there. You don't really have any direct proof of this person did that. You know, you can still argue around it. Direct evidence is a direct eyewitness saying, no, this is exactly what happened. It's a videotape saying, no, this is exactly what happened. So it's just more reliable.
Okay. So before I get into more explanation, I'm going to ask you guys a question. Can you win a trial based purely on circumstantial evidence, do you think?
No, I don't think so.
Okay. Sorry, who was that? Nikki?
Yeah,
What did you say?
I said no,
Why no?
because that's just what you think happened in the case, but you're not justifying it with any like actual evidence or fact.
Okay. All right. So I'm going to go ahead and we're going to talk about this a little bit more. First thing is I'm going to go back to what's more reliable or what's better. It depends. You don't necessarily, there really is no good, there's no hard and fast rule on which is better. It depends on your fact pattern. You may not have any direct evidence, which is why I asked you guys that question. So you actually can win a trial with all circumstantial evidence. In fact, if you have a ton of direct evidence, if you have a videotape of some guy robbing a store, they're probably not going to want to go to trial against you because that's like, hey, caught red-handed. But that's not always what direct evidence is. Let's just say you've got a murder case, all right? You guys have all been promoted. You're now officially district attorneys or public defenders. And you have a murder case, and the prosecution has direct evidence that the defendant owns a gun. They've seen the gun in his hand, and let's just say the guy's got a picture on Facebook or Instagram. He's got a gun in one hand and his gun registration in the other. That's direct evidence that he owns a gun, but that's not direct evidence that he used that gun to kill somebody. So I don't want you guys to think that direct evidence is evidence that shows a person doing that crime. It's just a piece of evidence that specifically talks about a fact. So going back to our cases, and we'll use Ronald Smalls, there was a fight in that case. So let's just say that before the fight started, someone took a picture of of Ronald Smalls and the person he had fought with in the same room or at the same bus stop. That's direct evidence that they were in the same spot at the time that a fight occurred, but that's not direct evidence that a fight actually occurred. So I want you guys to use your brains a little bit and think about direct evidence doesn't necessarily mean direct evidence that the crime happened. It's just actual evidence that shows a fact. So getting back to whether or not you can win a trial with or without circumstantial or without direct evidence, you absolutely can. In fact, like I said, most trials will, if there's a lot of most trials let me restart that sentence over. Most trials are mostly circumstantial evidence that you have to put the breadcrumbs together so a jury or a judge can look at it and say, okay, all these pieces of circumstantial evidence show that this may or may not have occurred. So just think about that as you're prepping your cases. So I see Caleb and Mackenzie have your hands up. Do you guys have questions, or were you just answering previous stuff?
Sorry, that was an accident.
That's okay. Caleb, same thing?
Yeah.
Okay, no worries. All right. So does anyone have any questions about that explanation of circumstantial and direct and any of the differences? Okay, Felipe, you said you have a question?
No, I didn't.
Answered her previous thing. Okay. So I don't want anyone to walk out of it. If there's one thing you learn from today, circumstantial evidence is not bad. I use circumstantial evidence all day in my trials because honestly, if I had direct evidence of a person doing the thing I'm accusing of, I'm just going to hand it to the defense attorney and be like, you really want to go to trial on this? Sometimes they'll say yes, and it's a short trial, but most of the time they're like, okay, we're done here, and they won't go to trial. So, all right, so how do we get evidence in? Do you think, we can't just say, well, I have this evidence, so everybody knows it. You have to get it admitted. And that's where we're going to go next, is we're going to discuss the admissibility. Now, I was really hoping Judge Sullivan would be here today because he is a judge, and that comes into play with this thing specifically, because a jury doesn't decide what evidence gets in, the judge does. So there's two things: there's admissibility of evidence and the weight of the evidence. So if it's a jury trial, the judge will decide if that evidence comes in, and then the jury will decide how much weight to put on it. Like, how important is that fact to my case? So you may have 100 pieces of evidence, and 99 of them are just like, I don't really care, but then there's the one piece that they're going to put the most weight on. But the jury doesn't get to decide that, the judge does. So there are several things that you need to decide or consider when looking at evidence. The most important is relevance. How relevant is this evidence? Is it relevant to my case? Now, can anyone kind of give me an explanation of relevance? You can either unmute your mic or just raise your hand in chat and I can call on you. Mira.
So for evidence to be relevant, it basically has to like tip the scales, so to say, in one direction or the other. So it has to either like prove or disprove a fact for either the defense or the prosecution, like one way or another, so that it like creates more favor for one side.
That is correct. It's exactly how it is. So my evidence professor, when I was in law school, he was a big sports nut, so he would always use football. He said, it's got to move the ball one way or another. If it doesn't move the ball either way, it's not relevant to your case. So for you sports fanatics out there, that's another way. But Mira's example of tipping the scales is probably more appropriate since we're talking about usually the scales of justice. So I like that. I might steal that for later. So that's always something that you can bring up if you want to. I know we're not talking about objections yet, but that's always an objection you can use in a trial. Objection relevance. What's the relevance of this evidence? So that's the first thing you want to discuss. You also want to discuss the reliability of that evidence. Now, it's got to be trustworthy. You want to have, you can't have anything photoshopped or written on. And there's also another factor in there that you'll get into a little bit more next week, but I'm going to briefly touch today is reliability of your witness. Now, what I mean by that is you may have a witness that has a fact, but let's just say that person doesn't come off very trustworthy. They don't present well. You're prepping them and their answers kind of come out. Let's say they're like looking all over the place, or they're kind of not enunciating very well, or if you're sitting there looking at them, you're like, I wouldn't believe that person. You might not want to put that witness on because while you may know that that fact is true, if you don't think you can present that fact in a reliable way, it may hurt your case. So you always want to consider what the reliability of the evidence is. So another example of that is, let's just say, let's look at our case. We've got Ronald Smalls. He was involved in a fight. Let's say you have his very best friend that he's been friends with for as long as they went to the same school, kindergarten together. They've hung out every other day since they were born. They are best friends. And he comes up and he's like, Ronald Smalls didn't get into a fight. And never would fight, doesn't like to fight, doesn't do this, doesn't do that. He was never there. Do you think that's a reliable witness? I see Haley. Is it Hallie or Haley Goring shaking your head? So I'm going to call on you because you're very confident in that. And tell me how to pronounce your name so I don't mess it up.
It's Hallie.
Okay, Hallie. So you were giving me one of these. Why is that not reliable?
Because they're their best friends, so they're more than likely biased about the situation. that like, oh, he wouldn't get in a fight, but like it seems like he's sticking up for his friend.
And you use a very good word there. Thank you. That's exactly correct. Bias. Bias is something that you're going to learn later. I'll probably touch on it indirectly this week, but definitely next week when you're talking about witnesses and objections, because people have a bias. If it's a best friend, they're going to say anything to bail their best friend out. Even expert witnesses can have bias because, you know, if Hallie's got she's a prosecutor and she's got an expert witness, and the defense attorney gets up there and says, they're questioning the expert witness and say, you've done 20 trials as an expert witness. Isn't it true that all 20 of those have been for a prosecution? And they say yes, that might show a bias towards a prosecution. So good words. Hallie gave us a preview for next week. So good job, Hallie. But she's absolutely correct on the reliability. Next, we're going to talk about evidence that's not unfairly prejudicial. And I got some questions about that in Discord. So I'm going to go over that in a little bit of detail. So you are always weighing the probative value over the prejudicial value. And we're going to explain that is the probative value. All evidence that's relevant has a probative value. It just might not be a lot of probative value. So let's just say we're going to go back to Ronald Smalls, and you've got evidence that shows he had a backpack on that thing. Now, how probative is that evidence? Well, it could be a little probative depending on the facts. If a witness said, well, he had a backpack on that thing, you've got evidence. Now that's evidence that shows that somebody was there with a backpack. It's probative. Is it prejudicial? Probably not, because it doesn't insinuate one way or another that Ronald Smalls fought somebody. Now, let's say I've got evidence that we're going to change the facts up a little bit. Let's just say I'm on trial for arson, and you have 100 pictures of me, or I'm sorry, you have 100 pictures of let's say I don't know, what's emotional? Like a preschool. Let's just say after hours. There's no kids in there. After hours, and you've got 100 pictures of this burnt down preschool. The toys are melted. The fire was so hot it melted a swing set. It's emotional value. Like look what all this damage did. Someone tell me, is that probative? How much is that probative, and how probative is it? So someone go ahead and raise your hand. Samuel, go ahead.
It's not probative because it doesn't pertain to your specific case.
Okay. Why does it not pertain to my specific case?
Because you aren't on trial for burning down a preschool. And the preschool that was burnt down is specifically being used just to make it sound like you are the one who.
But if I'm on trial for arson, isn't that evidence that an arson occurred?
Yes, I suppose it is.
Yeah. So I get where you're going with that, but it would be probative. So I see, is it Jillian? All right, yeah. Jillian, how probative do you think that is?
I think it is. I kind of related it to the example that we were given with, I think you said it was a penny when it was talking about, I think it was a marijuana case. It kind of sets it in perspective. Yeah, I think it's very probative. I think because especially since it is an arson case, it is, obviously introduces that emotional aspect to the arson case.
Now, is it prejudicial? You tell me. You're the judge. Judge Grimm, I'm making a motion that is too prejudiced. It's overly prejudicial. What's your ruling?
I guess, yes, it could be. Yes, it would be.
Why? Tell me why.
I think because that's interesting. I mean, it's not necessarily a fact of the case. It's a piece brought in to inspire the jury emotionally. So as much as it has to do with arson, it's not necessarily, I don't know. I'm kind of
That's
stuck.
fine. That's okay. Okay, we got more people, so thank you. That you're not wrong, and no one's going to be wrong on this. So I'll explain why. So we got a lot of people. So I'm going to try and go in order who raised their hand. So I got Crystal Villerin.
Yes.
What do you think?
So I do think it's prejudicial because that's clearly that evidence was admitted to sway the jury in that direction. And I feel like in that case, you would move the court to admit and discuss it with the judge privately out of court because oh, wait, is that the right one? Well, I forgot the exact, exact term, but motion in liming. Motion in liming.
Lemonade, correct.
Limit.
Motion in limeade. That's how I remembered it when I was in law school.
Yeah, so I would do that instead because that would be kind of unfair to prosecution or to the opposing side in that case.
Okay. All right, that's a good answer. So we're gonna go talk to Nikki, and then we're gonna talk to Isaiah, and then we're gonna talk a little bit. So we'll go Nikki. Nikki, do you think it's too prejudicial or no?
Well, I don't really know, to be completely honest. Like, it's kind of a little complicated because the pictures like show what you did and they prove that arson did occur in the preschool.
Okay.
But at the same time, when you introduce arson in a preschool, that's obviously gonna like give emotion to the jurors. I don't know. I guess it depends on if there's anything that like proves you were there and it proves the extent to your crimes, but I don't know if like you need how much photos you need when showing that evidence off.
Okay, that's a good answer too. And then last one will go Isaiah. Isaiah, what do you think?
Okay, so personally, I don't think that it's like too prejudicial. And that's just because like the crime was arson and the preschool, like that did happen to the preschool. And so I feel like it is the same crime. And if that is what happened, like if he did burn down the preschool, I don't think that would be too prejudicial because like that's what he did.
Okay.
And I think like, yeah, it might sway the audience like in an emotional way. But I don't feel like that is bad. That just means they're using like a pathos argument. And that's just the approach they're taking for their case.
Okay. I like the pathos argument there. Very, very well done. So there's no right or wrong answer. It really depends on the judge. The judge may say, you burned down this is a case about burning down a preschool. You got 100 pictures of the preschool. Now, if you got like, a difference might be, and again, there's no, like I said, there's no right or wrong answer. Let's just say you've got 10 pictures of the same toy melted from 10 different angles. You probably don't need that. You might only want to admit one of them. So it really just depends on what the judge thinks, how you present it, so I'm asking you guys these questions. It's going to get your brains thinking because when you put evidence in, you're going to have to think about that. Like, is this too prejudicial? I don't know. Any piece of evidence that's going to come in against the defendant is going to be prejudicial to the defendant. What you need to weigh is the probative value enough to overcome that. So it's just an analysis that you kind of have to do, and the judge may or may not agree with you. So like I said, no right or wrong answer. Everyone gave good answers there. So we're going to move on to the next thing here, which is not privilege. We're going to be really brief here. I will say, if you could do me a small favor, Philippe, or I'm sorry, not Philippe, Isaiah, if you can possibly move your camera to your right so we don't have a cat with a middle finger on our recording. Thanks. That's okay.
I'm sorry.
No, you're good. You're good. No, you're fine. You're fine. We're all adults here, right? So I just don't want Patrick or Kathy to yell at me. So we're going to go into privileged information. And this may come into play a little bit with you guys, but it might not. It really just depends on your case. But privileged information is information that you and your client discuss. The prosecution isn't going to have this as much because you're not really talking to anybody. So this is more for people that are on defense. If your client tells you something in the capacity of their defense, if you're in a room alone with them and they tell you something, that evidence can't come in. That's privileged information. There's ways to break privilege, but there's a laundry list of them, but essentially don't talk to anyone about the case or things that they have told you, and make sure that your client doesn't talk to anyone. Because if they tell you, yeah, I punched that dude in the face, but then they go outside and say, yeah, I punched that dude in the face, you don't have privilege about that anymore. That fact is out there. So you probably won't run into it too much, but that is just one more thing that gets revealed. Or excuse me, one more thing to consider. So we're going to go into foundation next. And foundation is very, very important because you need to lay a foundation for every fact that you bring up. Does anyone want to give me, actually, no, I'll just cut right to it. We're going to go to witnesses. Basically, it's why is this piece of evidence reliable? So we're going to say, we're going to go to Ronald Smalls. One of the potential witnesses in that case was the principal. So if you're questioning the principal, you don't want to just jump right in and say, you were at XYZ Elementary, I don't have the school name in front of me, on this day, were you? You don't want to do that because you haven't really laid any foundation as to why. So you want to start with their name, what's their occupation, because their questions are going to lead you down to where you want to go. And then I'm the principal of Ronald's school. Okay, so as the principal of Ronald's school, like, were you there on the date of the incident? Yes. Okay, can you tell me what you were doing that day? Because if you just jump straight to the incident, objection, foundation, how do I know, why do I know that they were there? So another example of this is, to give you guys like a real life example, I work with the Department of Family Services. So my main witness is always a worker with the department. I can't, and during our cases, they get case plans and they work their case plan. And that's one of the things that we use at trial to say, okay, well, you were given your case plan on October 1st of 2018. Did you do anything in your case plan? Well, you haven't established what a case plan is. So I have to start by saying, are you a caseworker of the Department of Family Services? Okay, yeah. In your job, what is it that you do? And they have to bring up the case plan in their own, in their own testimony. And then once they bring that up, then you can start asking questions about it. So you kind of want to start with your fact and then backtrack. So so let's come up. Well, we're gonna call on someone here who we have not talked to. I almost accidentally called on you, Katya. Sorry. Laura Soleimani, are you there? Laura Soleimani. All right, I'm gonna give you a fact pattern. Can you unmute your mic and talk to me for a sec? Okay, well, we'll come back to Laura. Laura, I'm gonna ask someone else a question and then I want you to give me an answer in the chat and we'll go over it that way. How about, who have I not talked to? Noah D, are you there?
Yeah, I'm here.
Okay, Noah. All right, we're gonna talk about our mock trial here real quick. So let me pull this up because my computer is being slow. Now, you're an attorney in this case, and I am one of the officers that was on the scene.
Mm-hmm.
How can you give me an example of how you would lay the foundation that I was at the scene? And then Laura, I want you to type that out too. Just kind of be brief. I know it might be a little bit long. So how are you going to lay? How are you going to? I'll tell you what. Let me get more specific. You want to get out the piece of evidence that I wrote a citation for Ronald Smalls. Okay. How are you going to lay the foundation for me to get there? You don't have to ask me the question, just kind of give me the roadmap of how you lay the foundation to get that piece of evidence in.
Maybe I would ask the police officer like what they do on a typical day, and then if they were there during the incident, and then perhaps like what they saw Ronald Smalls doing, and maybe even ask them specifically if they wrote a citation that day.
I think that's a pretty good foundation. You got the incident, why they were there, what they were doing, what they saw, and then what the result of what happened as a result of what they saw. So I think that's good. So I'll wait for Laura to see if she has a similar. Yep. So okay. So good. Both of you, good answer. That is exactly how you lay foundation. It doesn't need to be. You can go ahead and mute your mic, Noah. Good job. Doesn't have to be 1,000 questions. It's just sometimes it's just one question. But you want to get your fact and backtrack. I mean, sometimes, especially in cases like this, a lot of your foundation is going to kind of build upon itself. So you don't need to lay foundation. You don't need to ask. If you've already got a fact in, you don't want to put that fact in again. So let's just say you need to get. Let's just say, you know, the officer, after he wrote the citation, did something else with Ronald. As long as your foundation is already there, you don't need to go through the whole spiel again and like, okay, well, what were you doing that day to get to that fact? Does that make sense to everybody? So, all right, cool. All right, so any have any questions so far? I'll give it a sec just to make sure. All right, doesn't look like we got any questions. So we're gonna go on to reports, photographs, weapons, etc. Can someone tell me what kind of evidence this is? And I'll give you a hint. It's not direct or indirect. That's not what I'm looking for. Marie, go ahead.
They're items that were used or found at the scene of the crime.
It could be, but what do you know? What kind of evidence it is? Yeah, I can hear you. So there's two types of there's two ways to get evidence in. There's witnesses, and what's the other way?
Okay, those are exhibits.
So, I think I heard you say exhibit. Is that correct? Yep, you're breaking up a little bit. So it's so Marie's correct. These are exhibits because last time I checked, a report, a photograph, or a weapon can't testify. Yeah. So it's an exhibit. So good job, Marie. Now we can't just get exhibits in. We can't just say, okay, Your Honor, I'm putting this in. You have to lay the foundation for that. So you want to, you know, as you're, let's just say you're talking to the officer and he found a knife at a crime scene. So you have to go all the way through that testimony till he brings up the fact that there's a knife, and then you can use that as foundation to bring the knife in. Does that make sense to everyone? Does anyone have a question about exhibits? So you're not going to have too many exhibits in these cases, just because of the nature of the cases that we have. There's one type of exhibit that we probably would have. Now, can anyone tell me what that might be? It's in almost every case we have.
A police.
That's correct. Who said that?
Felipe, me.
Okay. So let me ask you this, Felipe. Is a police report admissible in all cases?
Typically in like an average court, no, but in trial by peers, they are usually very common.
That's correct. Okay, so for bonus points, Ellie, I asked him, I asked what kind of exhibits that we almost always have in trial by peers cases. Okay, so for the bonus round, why are police reports not normally admissible. And I got Catherine Bryan. I haven't heard from Catherine, so Catherine, I'm gonna let you go for the bonus points. Which I don't know what the bonus points will get you yet, but I'll figure something out. Maybe my cat will show up and you have a kitty picture. So tell me.
Oh, I just had my hand raised because I had a question, but.
Oh, okay. Well, you want to take a stab at this, then you can ask me a question?
Yeah.
Sure.
So, I'm sorry, what's the question? I was reading this, sorry.
That's okay. Can you tell me why a police report isn't normally admissible? And if you can't, that's fine.
Just because it would be easier to have the actual officer come into court and testify instead.
Okay.
So you can ask specific questions and he can be there in real life.
You have the theory of it correct. And I see some other people answering it. So it's because reports are hearsay. So you want the witness there to testify. So like in my courts, I can't admit reports because I need that person that wrote the report to testify. Otherwise it's hearsay. And we'll get to hearsay in a little bit. So what was your question?
It says on the outline that you can admit an exhibit in 3 ways, and the third way says to enter an exhibit via a witness. So how would you go about doing that?
Basically how I explained it. You ask them questions. So let's just say I see you have a water cup in front of you, right? Let's just say that water cup is a murder weapon now. And you're the police officer, you got in the room, you don't have to hold it. I just saw the water. So you walked in the room and that was the first piece of evidence you saw, and it's got blood on it. So so I would ask you as the police officer, so you went into this room, what was the first thing that you saw? Well, I saw this water cup with blood on it. Okay, Your Honor, I'd like to move to show State's Exhibit A, the water cup. So you want the witness to bring that up first. You can't just be like, yo, judge, I got a bloody water cup here. You want to it's basically providing context around it. So that's how you bring it in through witness. Okay, so I think we got a good idea of foundation. And like the outline says, that's going to be covered a lot more in depth during witness questioning because that's a big part of how you get evidence in. So we're going to go ahead and move on to witnesses. You want witnesses to be able to testify 3 things: swear to tell the truth, be competent, and have personal knowledge of events. Why is it important? We're going to go right to the third. Does everyone everyone understands swear to tell the truth? Competent is basically just they have to have the mental competency to testify what they're talking to. We're not going to put a 3-year-old on the stand to talk about a murder case. If the person doesn't have the mental capacity to testify, then they're not a reliable witness. So we're not really going to run into that too much. But having personal knowledge of events is probably the most important thing on that list. Can someone tell me why? Samantha.
I think that it's important. That way they're not like just playing a game of telephone. That way they know exactly what happened versus just what someone said to them. That's correct. And Coco is also correct. That's probably going to be hearsay more likely than not. So good job, both of you. It's very, very important to make sure you have personal knowledge because they essentially cannot testify to whatever that fact is if they didn't see it themselves or hear it themselves or anything like that. So we're going to go to the next portion, which is impeachment. Now you're going to learn a lot more about impeachment next week, especially because you usually want to impeach witnesses, but we're going to go over some of the things that you can impeach a witness with here. And unfortunately, I know we usually try and tie these things into the Ronald Smalls case, but given the fact that we're going to get into the end, we're going to discuss some evidence together. What do you think is more important? So I don't want to give away too much of that while we're talking about it. So evidence is a big thing. It's literally like an entire, my evidence class was almost a year long. It's a big, big topic. So we're going to kind of go over, the higher level view, and then the last 20, 30 minutes, we're going to go over things specifically to Ronald Smalls.
You will not subpoena witnesses, Samuel. That's done by our trial by peers people. So going back to the police report, one of the reasons that we allow that evidence in this case is because our trials are usually held after hours. So we can't always get the officers down there. And in addition to the fact that because we're a diversionary program and because we're a restorative justice program, we want to make sure that we're engaging in those principles as much as possible. We don't want one of our subject minors who, it's fairly obvious they may have done something, on a technicality, not receive the services that they need on a technicality that, a police officer couldn't show up. So that's the only reason that they're allowed in trial by peers cases. In real life cases, if your officer doesn't show, you don't get that evidence, and just end of story. Yes, witnesses are sequestered in normal court. It's called the exclusionary rule. They're not sequestered off by their own, but they can't be in the room while others are testifying. So we're going to go over some impeachment stuff. So who here, you can raise your hand in real life or shake your head or just say yes in chat. Who here has seen A Few Good Men? Or no, sorry, not A Few Good Men. Wrong Law movie. My Cousin Vinny. All right. Well, those of you who've seen My Cousin Vinny, you may know what I'm talking about. But if you haven't seen it, I would highly recommend getting it and watching it, because it has probably the best example of sensory perception and how to impeach someone about it. So there's a scene on there where there's a guy, he's in his house or in his room, and he sees the crime that happened across the street. And the attorney in there, Vinny, goes up there and he's like, basically, I'm gonna super cliff notes this for you, but there was like bushes in the way and a grimy window that he hadn't cleaned in 4 or 5 years that had this brown crud on it, and he didn't have his glasses on, like everything possible to discredit this guy, that he couldn't see something 200 yards away or 100 yards away or however long the distance was, because there was all this stuff in between him. And then there was another witness who swore it was the two guys that committed the murder, and she wore glasses, and her glasses were like the Coke bottlest of Coke bottle glasses you can have. Not that that's bad, but she didn't have the right prescription, or I forget exactly what happened, but she couldn't see it. So the whole point was, how could you accurately see the crime if you didn't have your glasses on? It was the prescription wasn't strong enough. Like, because she put the glasses on and he walked to the back of the courtroom and was like, held up a letter. What do I have? So again, I'm paraphrasing a little bit, but that's sensory perception. Another example, let's just say a person wears hearing aids. If that person's got hearing aids and they heard something, you want to know, did you have your hearing aids in? When's the last time you had your prescription checked for your hearing aids? Were your batteries fresh? Was the volume on correctly? Anything that may show that witness had some kind of auditory or visual, or something was in the way, that's a perfect way to impeach a witness. Because how can my testimony of something I saw be accurate if there was a tree, a bush, a grimy window, all this stuff in the way? How can I see that properly? So if you get a chance to watch it, it absolutely is probably one of the best ways to explain that. My law professor, that's what he literally just showed that clip in evidence that day and said, I'm not going to teach you sensory perception, watch this. And that's all he did, and that explained it. So you can impeach someone with a prior and consistent statement. Now, you have statements made by several people in your Ronald Smalls cases. So you want to study those, because if your witness is up there, or let's just say you're the defense, and the prosecution calls one of the police officers, and the police officer said, I arrived on this, in his statement before court, I arrived on the scene and Ronald Smalls was wearing a blue t-shirt. Okay, simple, fairly innocuous fact, right? Kaiden, I'll get to your question in a second about the reports. And then the day of trial, he says Ronald Smalls was wearing a purple t-shirt. Now, it might not seem like an important fact, but you can take that and say, well, didn't you provided a police report before this case, didn't you? Yeah, okay. Isn't it true that you said that Ronald Smalls was wearing a blue t-shirt? Did I say blue the first time? Let's just pretend I said blue, I can't remember. Yeah, and he's like, well, maybe, okay, well, you know, you either you did or you didn't. Did you or did you not? And he said, and whatever they say that you win. Because if he says, well, yeah, I said, okay, well, didn't you just testify that he had a purple t-shirt on? So are you lying now or are you lying then? And he might not be lying, but basically what you're trying to show is what either he wasn't paying attention back then or he doesn't remember what's happening right now, and you've hurt his credibility. So to give you a little bit of a stronger answer, let's just say you're all personal injury attorneys now, okay? And you questioned me before the accident. You're a big accident. A Walmart truck drove through an intersection and T-boned somebody, right? And at the time of the incident, I get interviewed and I say, well, yeah, the stoplight for the truck was red. Okay, that's good fact. I go to trial and I say, oh yeah, stoplight was green. And you have the statement right here in your hand. It's like, isn't it true that you gave a statement before the case? Yeah. Okay. Isn't it true that you said that that stoplight was red? And if they say yes, then that's it, you're done. You can just say, well, but now you're testifying it's green, so which is it? You know, how do I believe you now or do I believe you back then? If they stick with their previous story, then this is how you impeach it. So who can I pick on? I'm gonna pick on somebody. Not really pick on you, but I'm gonna show you a little trick that I learned. Sarah Park, you have a cute puppy photo. We're gonna call on you. Are you there, Sarah?
Yes.
Okay, Sarah, you're gonna just say a whole lot of yes and no right now, okay? So we're gonna pretend that at the time of the accident, you said the stoplight was red, okay? And then you just testified in trial and you said, well, the stoplight's green, okay? So I want you to stick to your story that the stoplight was green, okay?
Okay.
You got that? And then this is going to be my fake police report, okay? So I'm going to teach you guys a little something, and then maybe one day if I have you for a senior attorney, I'll teach you how to do this. So, okay. Miss Park, did you just testify that the stoplight was green?
Yes.
Okay. Now, would you always say that the stoplight was green?
No.
Oh, so it's possible you could have said the stoplight was red then, right?
Yes.
Isn't it true that you gave a statement to the police before this trial?
Yes.
Okay. Isn't it true that you were asked what color the stoplight was?
Yes.
Isn't it also true that you said the stoplight was red?
Yes.
Okay. So, see what I did there? So now it's like, well, do we believe what she says? Who wants to believe her right now? Okay. So now I'm going to call on somebody else. Thank you, Sarah. I didn't mean to pick on you, but we're going to call on someone else now, and I want you guys to stick to your guns and be snarky to me. Trust me, it'll be fun. Let's see. Who haven't we talked to yet? I've got Kayla Gowdy. Are you there, Kaylin?
Yes, I am.
All right, Kaylin. We're gonna have some fun, okay? I want you to be a little mean to me, be a little sarcastic. So same thing, except I don't want you to just say, nope, stoplight was green. I don't know what you're talking about, okay?
Okay.
Okay. So Miss Gowdy, you just testified that the stoplight was green, right?
Yes.
Okay. Now, would you always say that the stoplight was green?
Yes.
So you never, ever in the past would have ever said the stoplight was red, would you?
No, I wouldn't have.
All right. Isn't it true you took an oath to tell the truth today?
Yes.
The
Yes,
whole
I
truth?
did. Yes.
Nothing but the truth, right?
I'm telling the whole truth.
Okay. Now, you gave a statement before today, correct?
Yes, I did.
During that statement, didn't you also swear to tell the truth?
Yes, I did.
The whole truth?
Yes.
Nothing but the truth, right?
Yes, correct.
Okay. I'm going to show opposing counsel page 2 of Ms. Gowdy's previous police report statement. Ms. Gowdy, isn't it true that during that police report, you were asked the question, what color was a stoplight?
Yes.
Isn't it also true that you told the police officer that stoplight was red?
I said it was green.
Oh, okay. Your Honor, can I approach the bench? I need Judge Gearing because I can still see your picture. Give me a yes or a no. Can I approach the witness? You need to say yes. I'm going to go up anyway. Sorry, Judge Gearing, you're taking too long. So, okay, Ms. Gowdy, I'm showing you, it's a blank piece of paper, Kaylin. Play with me for a minute. I'm showing you the police report. Isn't it true that that's your name on this police report? Just say yes.
Yes, that is correct.
Isn't it true that that's your signature right there?
Yes.
Say yes. Okay. I'm going to refer you to page 2, line 3. Isn't it true that that line states what color was the stoplight? Say yes.
Yes.
We're pretending the stoplight, the police report says it's red. Okay. Isn't it also true that your answer right here on line 4 is the stoplight was red?
Yes.
Okay. No further questions.
Oh.
You're impeached. So I'll teach you guys how to do that a little bit better. But basically what we call that technique is pushing them up the cliff and then pushing them off. So if they stick to their guns the whole way and you have a police report, now normally what you want to do, you got to be a little theatrical, right? You get up there and if they say, okay, you get the whole truth thing and then you kind of, do one of these, crack a little bit. Isn't it true that you gave a police report, right? They know you've got the police report in your hand. If they keep sticking to it, you're just going to show it to them and say, you said it. But if they do that, that's the best thing that can happen to you because you just destroyed their credibility. So that's how you impeach with a prior inconsistent statement. So read every single word of their previous statements and pay attention to what they're saying when they're testifying for the other side. Because if they say something wrong, that you just start rubbing your hands because that's exactly what you want them to do. Because it doesn't matter what they say afterwards. If you get them like that, they're toast. Now, the only thing that you need to do is you need to watch your witness. Now, if it's just some little old lady who probably just forgot, you don't want to go up there and grill them like I just did Kaylin and Sarah. You want to be like, isn't it true you might have said this before? Like, read the room. Now, if they're up there like, yeah, I said it was green, you're like, okay, pal, let's go. That's when you put your game face on and you go after them. So you got to read the room a little bit, but you always want to pay attention to what they said before and what they're saying on the stand. It's the perjury questions, it's really hard to get perjury. You have to know for a fact they were lying. It's hard. I've never seen it happen. It's a pretty high standard because it's like a separate charge. You have to charge them with perjury and then bring them on and prove that they knew they were lying. So it's hard to do. And I don't think we've ever had a perjury. No, I can tell you with almost 100% certainty. If Katya, Patrick can correct me if I'm wrong, but I don't think we've ever had a perjury case because again, they would have to be charged with perjury. It's not like you just tell the witness you've perjured yourself, you're going to jail. You have to put them on their own crime. So it's a whole separate trial. So, all right.
Yeah, we haven't had it.
Okay. So that's a prior inconsistent statement. It's super fun. And yes, it can be serious and you can definitely be snarky with your witnesses. So I've got to do it in a few trials and it's pretty hysterical because they don't realize what's happening when they're sticking to their guns. And I'm just making it look bad for you. Okay, so bias and motive, we already kind of went over that. If you got a best friend, that's a bias. They could have a motive for what they're saying. Like I say, if you've got an expert witness and they're getting paid and they're always prosecuting witnesses or they're always defense witnesses, you're kind of like, and you're an expert witness for that side today. You want to bring that up. Isn't it true you're being paid to be here today? Isn't it true you're being paid $5,000 an hour to be here today? To show that there might be some incentive for them to say what they said. So it's always good to bring up if you can. Prior bad acts. This is kind of a hard concept to explain and it's even harder to get around in court. So what I can say about it is this, let's just say you have someone who steals people's cars at gunpoint. And they've stolen 17 cars before this, and you're on trial number 18. And you want to bring in evidence that they've stolen 17 cars. The only way you can get that in is if you're trying to prove like their motive. Let's say they always steal cars with a purple ski mask with glitter on it, and a handgun painted red, white, and blue. Okay, they always do it like that. They're the purple. They're the glitter robber. I don't know. We'll come up with a bad name for them. If you want to bring the evidence in that they've stolen 17 cars to show that they've done it the same way 17 times, then you can get it in. But you can't bring in the fact that they've stolen 17 cars to support that they've stolen the 18th car. Does that make sense? It probably doesn't, because it took me forever to wrap my head around it. But there's a difference there. Okay, so that's prior bad acts. I highly doubt you will ever need that in trial by peers, but we're teaching you more than just trial by peer stuff, so I wanted to bring it in and talk about it. It's not that you can't be double penalized, Kaiden. It's that just because I've stolen 17 cars doesn't mean I've stolen the 18th. If that makes sense. And I forgot to answer your earlier question about police reports. Someone can testify that they wrote a report, but they can't testify. They can't, like, I can say, I caught Dave at 7-Eleven on this date. I can't testify. I wrote in my report that I caught Dave at 7-Eleven. There's a difference there. You're testifying to, the first one is testifying to what I did. The second one is testifying to what I wrote and what my report says. Those are separate things. We can, in trial by peers, use their reports, but in a normal course, if you have a witness, if you have the witness there, then no, you can't. You actually have to lay foundation for why you're admitting a police report in trial by peers. You can't just say, I'm admitting this. You have, especially if you get in front of Judge Sullivan, he's going to ask you why. You have to say, we tried to subpoena them, we tried this, I tried to call them today, they're not here now, they're an unavailable witness, and because of that, I'd like to admit the police report. If they're there, you don't need for them to admit the report, you have them to testify. Catherine, that's a hard question. It's multi-layered. First of all, if you're the prosecution, you can't admit character evidence to start. And if the defense attorney is dumb enough to say, my client would never steal a car, I mean, go for it. They may object and say, well, that's prior bad acts, that can't come in. But you're at the mercy of the judge right there. Then it's a battle of prior bad acts versus, well, the defense opened the door for character evidence. So it depends on the judge. But I highly doubt you're going to get a car thief saying, yep, never stolen a car in his life, and he's got 17 convictions on his record. All right, so that takes care of impeachment. So that was a good segue. We're going to talk about character witness. So I know some people had a question about the term of art that we used on the homework and the handouts. Prosecution can't bring in character evidence until the defense opens the door. And that is an actual technical term that's used, a term of art that's used in the law. So if you have character evidence as a prosecution, you cannot bring it in at all until the defense does it first. And then if you're the defense, you want to make 100% sure if you're bringing in character evidence, there is no evidence that can dispute that, because you're just going to kill your own case. You know, if you got a Ronald Smalls, you got Ronald Smalls here. Ronald Smalls has never gotten into a fight in his life, and the prosecution can put the principal up and say, Ronald Smalls has gotten into a fight every 2 weeks since he's been to this school. You're toast. So just make sure before you bring character evidence in, you are 100% certain there's no evidence that can rebut that. That's for the defendant. all other witnesses, essentially, the blank is opens the door, opening the door. Any other witness other than the defendant, the only character evidence you can bring in is whether or not they're about their honesty. So if you have evidence that they're liars, you can bring that in, but that almost never happens. Usually you impeach them at trial, that takes care of it. That's correct. The defendant in criminal cases, and this is criminal matters, can only be called by the defense. You can cross-examine them if they are called, but you can't actually call them first. How come the defense
Hey,
can
Kaden
only...
does.
Sorry? Kaylee Saleh, do you have a question? Okay, looks like that might be just an accident. Ariana, that's just one of the rules of evidence. I assume it's so the prosecution doesn't pile on. I guess that's I don't really know why the rules of evidence have that, but I guess it's just a matter of if the prosecution can put character evidence on and they got someone who's just a bad dude or a bad person, you can lay all this evidence on top, and you probably, you don't want to do that. You don't want to be unfairly prejudicial. But if the defense opens the door and gives you the opportunity, then it's fair game. That's the only thing I can think of. The defense attorney tries to talk about how much of a good citizen. Yes, that's correct, Felipe. And if you've got evidence that they're a bad citizen, then you can go to town. So that's pretty much it for character evidence. You're probably not going to deal with it too much in trial by peers. So does anyone have any questions about character evidence? All right. We're gonna go to hearsay and exceptions. I'm gonna go over this extremely briefly because hearsay is its own class, essentially. It's extremely it's an extremely difficult concept. The bottom line for our cases is if you didn't see it personally or hear it personally, it's hearsay. There's a lot of other information that we put on there, and that is, you guys can review that on your own. And then as we get further in the class, I would say, or if you're prepping for a trial and you want to ask if it's hearsay, I'd ask your senior attorney. I'll real quick, if anyone's got any specific hearsay questions, I can answer them real fast. But I want to get to some other things here. It's just it's not something we deal with in trial by peers a ton. But I wanted to add it in there because it's important information for you guys to know, and it's good to start trying to learn the concept now. So does anyone have any questions about hearsay? Does anyone 100% understand hearsay completely? And if you raise your hands, you're a liar, because no one does. It's a very hard concept that regular attorneys, it's like one of those things where I can't explain hearsay, but I know it when I see it. Not even that. Felipe, what's your question?
So my question is, in the event that you have a witness testifying and you ask a witness a question and they respond with, "Oh, so-and-so told me that this happened." I imagine that would be an objection of hearsay?
Yes, objection to hearsay and move to strike. Yeah, if they say, well, Dan told me, objection, hearsay. That's as soon as you hear someone say, well, I was told, boom, object right away. Don't even let them get what they were going to say out, interrupt them if you have to. That's about the only time it's acceptable to interrupt a witness is during hearsay. Because here's the thing. If you ask me a question and I say, well, Johnny told me that Steve stole the lunchbox, they can object to it afterwards, and the judge can tell the jury, you're not to consider that evidence. But if you're sitting in the jury, are you going to consider it still? No matter how hard you try not to? You're going to think about it. It's like me saying, don't think about green giraffes. Who's thinking about green giraffes? All of you. Same thing. Once the bell's rung, you can't unring it. So if you hear someone saying, starting to do hearsay, object right away. Mackenzie, I see your hand up. You have a question?
Yeah, so the only way you can object to a witness is if they're like speaking and they're saying like someone else told them something.
No, not necessarily, but for hearsay, you wanna object to them. You can object to usually, excuse me. Usually, you're objecting to questions that get asked, but hearsay is the most common thing you want to object to the witness saying it.
Okay, thank you.
All right. So for the sake of time, I put a lot of hearsay objections and non-hearsay. If you guys want to ask me specific questions about that, just shoot me a message in the Discord or shoot me an email. We can talk about it. I just want to put that in there for you guys for your own information. So we're going to touch on exhibits real quick because we kind of went over it a little bit earlier. Anything other than testimony is an exhibit. Pictures, videos, maps, charts, weapons, clothing, reports, backpacks, anything that you can hold in your hand is an exhibit. Why is it important? Why are exhibits good? Someone want to tell me why an exhibit's good? Anybody?
Because it's tangible.
Right. Why is that good?
Because you can't debate whether or not it's real. You can't like with hearsay, you can say, well, they could have just said that. It doesn't necessarily make it true, but having an object with somebody's DNA on it in front of you, it's not debatable.
That's good. That's a good way to put it. I'm seeing physical proof. I'm seeing irrefutable proof. It depends on it depends on what that, not every exhibit is a smoking gun, So while it can be irrefutable, it can be physical, it's not, remember, not every piece of evidence is aha. A lot of the times it's a puzzle and the picture isn't clear until you have all the pieces in place, right? Sometimes you only have 75% of the pieces and you can still see what the picture is. Sometimes you need that last piece or the puzzle isn't complete. So that's kind of trials in a nutshell is, do you have enough pieces for your picture to be viewable? So that's another good way to look at it. And it's just better. Sometimes it's better to have something in person, I have, do you guys know what those Funko Pop things are? You probably all do. I never really liked any of them, but I like the show Parks and Rec. And there's a dude on there named Ron Swanson. He's hilarious. So I have this awesome Ron Swanson Funko Pop. He's standing there with his frown and his mustache. He's holding his coffee cup, just pictures in the show. Is that a pretty good description of what Ron Swanson is? For those of you who've seen it? Yeah, probably. Is it easier for me to just do this? That's the difference. If you can put physical evidence or an exhibit up, it's picture's worth 1,000 words, right? Same thing. All right. Admitting exhibits. Last thing we got on our outline here. Admitting exhibits. There's 3 ways to do it. You can stipulate, which basically is a fancy lawyer term for you both agree that it's going to come in. And sometimes that's good. Sometimes you can get a report in. Coco, it kinda. Sometimes it's just easier to show someone than explain it, if that makes sense. Sometimes it is for appeal. Sometimes it's just you want to, why would I explain something if I can just show it to you and it's easier for you to understand, Anyway, going back to evidence or stipulating. Stipulate's a fancy word for agree to let it in. And sometimes you can get things in, especially if the lawyer isn't 100% paying attention. So let's just say you're a defense attorney and you see that they brought the officer to testify. And if they put that officer up there, he's going to say in gruesome detail what happened. But he wrote a report. And you might be able to talk to the other side like, hey, I'm willing to stipulate to put the police report in so we don't need to call the witness. And if they say yes, that might help you, because normally, you know, the prosecution is the one who wants to put stuff like that in. But if you can put that in, then you don't have that officer up there to give a big detailed explanation of what happened. Sometimes it just saves time. Sometimes we both know the judge is going to let this piece of evidence in. Can we just put it in and cut right to the chase? And they say yeah. There's the motion in limine, which is it's basically, you know, it's before the jury gets in there. It's just the lawyers and the judge. Usually it's even before the defendant gets in there. It's just to sit down and say, hey, judge, you know, we have this evidence. I want to put it in. And the other, usually it's the other side that's asking for the motion in limine, because they don't want the jury to hear what that evidence is, because if they start to hear about it, they may draw their own conclusions. So if you've got if the other side has a big piece of evidence that you don't want to get in, and you think you have a good way to not get it in, ask for a motion in limine, because you can discuss that with the judge outside of the presence of the jury, which means if it doesn't come in, the jury never even hears about it. It's like it never existed. So does anyone have any questions on that? Because that's an important tool that you can use. Yes. You just ask the judge, I'd like to have a motion in limine. In trial by peers, he may ask the jury to leave. He may just have you guys come up and you whisper to the jury, or sorry, you whisper to the judge so the jury doesn't hear. Motions, and specifically motions in limine, are usually done before, but you can ask the judge to approach the bench. And it's kind of like, it basically serves the same as a motion in limine, but in professional practice, you usually have to file a motion for a motion in limine, so you can have it done before the court gets in. Correct, it's a pretrial motion. But for the sake of us, you can still, because especially since the way our trials are held, usually once the jury's in, they're in. So if you have a motion in limine for trial 2, but you're in the, you know, trial 1's going on, you know, either tell the judge beforehand, you know, Your Honor, when we start the case of XYZ versus XYZ, I have a motion in limine. And he may tell the jury to come out, or he may just say, okay, just come out and approach the bench when that trial, before that trial starts, and we'll discuss it. It just depends on usually what's going on. Most evidence is, Caden, yes. 95%, I'd say. Actually, 100%. There's no hiding the ball. And then the last thing that's on the outline is how you get the court to admit your evidence. So you always want to have your exhibits marked beforehand, like use a little sticky note or something like that. You want permission to approach the witness. You show it to the witness. You lay that foundation like we talked about before. You want to authenticate so they know that's the evidence that they looked at. Like, you know, let's just say you want to get a knife in. You can't just say, this is the knife, right? It's like, how do you know it's that knife? Well, it's the handle I saw. You know, I pre-marked it with my exhibit marker, you know, something that shows they you know, that's the same item, right? They have to have personal knowledge of it. And then once the witness does all that, you know, Your Honor, I'd like to move the court to admit state's proposes exhibit A. And they'll either admit it or deny it. Usually they'll ask the other side if they have any objection, and then they'll admit or deny. So does anyone have any questions about that? You're probably not going to have too many exhibits to admit. The police report is probably going to be the one the most. And realistically, because of why you're admitting it, you're not going to need to authenticate it really. You're just going to need to discuss with the judge why you're admitting the report, which means if you can't get a hold of one of the witnesses, you want to let Katya or Patrick know right away, most likely Katya. That way, when you go in front of the court, you can say, you know, I received this evidence on this day. I made 3 attempts to contact them. I received no response. I reached out to the trial by peers program. I spoke to them. They reached out a certain amount of times. You know, we had no confirmation that they're going to show up today. They're not here now. I'd like to admit the report in lieu of them not being present. And it doesn't need to be exactly how it's done. It's just, that's the kind of the thing you need to do. All right. So as far as the outline is concerned, does anyone have any questions? Going once, going twice. All right. Very briefly, anyone got any questions about the handout? I don't want to eat up too much time there. I just want to let you know. All right, I'm not seeing any questions. Jaden, go on and unmute your mic. You're going to answer your own question, buddy. Because that's going to segue us perfectly. What do you think?
I'm not too sure.
Okay. What do you have? Let's talk about this. What do you have?
We have our police report, and then we have statements from both Smalls and McKinney.
Okay. What else do you have to get ready for? What are you prepping? How about that?
The case?
Right. All right. Let me phrase it this way. Who are you prepping? Who was on your trial team?
The witnesses?
Right. So when you go to trial, are you going to have any testimony?
No. Yes.
Okay. Who's your testimony coming from?
The witnesses.
Right. So is the testimony evidence?
Yes.
Okay, good. And then, so are you on your trial team? Are you the prosecution or are you the defense?
The defense.
Okay, so who's your witness that you're going to call?
Smalls.
Okay. Now, is there anything else that you need to get? Do you think that you need to get in for your case?
No.
Okay, so you're just gonna have Smalls testify and that's it. And that's fine if you are. I'm legit just asking you.
I'm not too sure yet.
Okay, that's fine. So that's a good answer, Jane. You can go ahead and mute your mic. So you've definitely got witnesses. You may have some exhibits. So let's hear who's one of the prosecutors that I haven't heard from speak today. Why don't you go ahead and raise your hand, and then we're going to talk. I'm not seeing a lot. I'll pick somebody. I'll do it. I swear. I gotta get to my email, find out who. All right, we're gonna talk to someone.
You prep your client.
Sorry.
You prep your client.
Okay, so are you, Jacob, are you a prosecutor or are you a defense on this case? I see Jacob's iPhone. Are you a prosecutor or are you a defense?
Prosecutor.
Okay, who's your client in this case? Your client's the people, right? Because you're the prosecutor?
Yeah. Sorry, my Wi-Fi is just glitching out.
That's okay. That's okay. So, can you really prep the entire state of Nevada? If you can, I'd be super impressed. So you want to prep your witness?
Yeah, the people who were wronged.
Right. Okay. All right. So, Carolyn Gephardt. Thank you, Jacob, for that answer. Are you there, Carolyn?
Yes.
All right. You are a prosecutor on one of the cases that I'm going to judge. So I have your name, so I'm going to talk to you a little bit. As a member of the prosecution, what's your evidence?
My witness or witnesses and the statements along with. Yeah.
Who is your witness?
The people, I'm the prosecutor.
Right, but what witness are you going to call?
McKinney.
Correct. Okay, so that's piece of evidence. So why are you, what do you think is important about McKinney's testimony or evidence he can present? You don't have to give me the specifics. Just tell me what's important about that witness.
Well, McKinney was the other person involved in the fight and also knew Ronald Smalls.
Okay. So if you are, can you just name one important fact that you think will be good evidence to get testimony from?
McKinney was in the place. Sorry.
You're on the right track.
He was in the same place as Ronald Smalls when the officer came, so they were both in the same place.
Okay, that's good. Do you think it's important to show that somebody was in the same spot as somebody that they were allegedly in a fight with?
I'm not. Well, yes, because it's kind of assumed that they were also in the same place because they were both involved. It proves that they're both involved.
They were both there, right?
Yeah.
You can't have a fist fight with somebody if they weren't there unless they have superpowers.
Yeah.
Okay. So I know that sounds super basic, but it's a good fact. Like, I need to prove that that person was there with Ronald Smalls, or else how can I prove that that person was there? That makes sense? I know it sounds like repetitive, but it's an easy fact. So good job, Carolyn. So I'm gonna be asking everyone questions now. I just want to let everybody know your mock trial is more about performing and practicing than it is about hiding the ball and knowing facts. So don't be afraid to give away your trial strategy or anything here, because you guys are all working on the same case. You guys are all practicing with each other. You don't want to hide anything. So don't think you're giving anything away here. So this is just a discussion to get everyone's brains going and thinking about what's important, what's not important, things like that. So let's talk to, hold on one second. Ellie Griffith, are you here?
Yes, I'm here.
Okay, so you are Carolyn's co-counsel, right?
Yes.
Okay. What else are you gonna bring in?
Well, I was just going, I haven't put too much thought into it yet.
Okay.
And I was going to do similar things to what Caroline had said, but also like finding out if there's any video evidence.
Okay, if I told you have all the evidence that you're gonna get right now, you have statements, then you have police reports. What do you think would else be important to get in?
I think that would be it then. If we already have all the evidence and the statements and the police reports and the witnesses, I don't think for this case there'd be anything else we need.
Okay, well, so you're in trial right now, and Carolyn just questioned McKinney. So
Yeah.
what other piece of evidence, do you have any other evidence that you want to admit? Nothing else is in right?
If I had more time, I could probably think of something, but right now nothing is coming to mind.
That's okay. Jana, go ahead and unmute your mic. You're correct. That's something you could admit. Why would you admit it?
Because it states the citation and what we're trying to, for prosecution, what they were trying to prove that happened incident, which is the disturbance of school.
Okay. Now, why would you admit that as opposed to, say, getting testimony?
Can you repeat the question? Sorry.
Why would you try and admit that as opposed to getting testimony?
I feel like you could get both, but I would try to admit the citation because it has all the different parts of the statement, and like you can get the details about each person as well.
Okay. Let me ask it a different way. Why are you admitting that as opposed to calling the police officer that wrote it?
Oh, because for the trial by peers, the police officer, especially in this case, is like, this is past tense. This happened before, and the police officers might not provide the same information that they did, and they might go over into detail.
Okay. So are you saying that if the police officer was available, you wouldn't want to call them?
I would want to call them.
Okay. So that's kind of a trick question because we kind of pre-picked the witnesses for you. So thank you, Jana. The reason that you might want to consider admitting that is because the police officer isn't available as a witness. You guys have the two witnesses that you're going to get. Now, if you had the availability to call that witness, you'd probably want to call them instead of admitting the citation of the report. Kaiden, I'm sorry, Caden, I don't want to mispronounce it. So unmute your mic, correct me, and then we'll talk about what you just said. Because
it's Caden.
Okay, sorry. We had a Kaiden last time spelled the same way, so I keep switching it. So, okay, Caden, what do you think? Are you a prosecutor or are you defense?
Prosecution.
Okay. I'm gonna put your defense hat on. So take your prosecution hat off, put your defense hat on. You tell me, what do you think about that?
I think the discrepancies can show that it's not admissible.
Okay, well, so let's make sure you're using the right terminology. So if they're both in, they're admitted, right?
Yeah.
Okay. So if I'm the prosecution and I put in the citation first, okay, and you have the arrest report and you want to admit that to show that my citation evidence might be bad or inconsistent, what are you doing? We talked about
impeaching the report.
Huh?
Basically impeaching the report.
Correct. You're attempting to impeach that evidence. Now, in this case, if this was a real life case, like a real life case, not trial by peers, we would probably have the officer on there and you could use them to impeach the witness. So you don't really impeach other exhibits, but because of how we do things, sometimes you have to. So that's the right way to think about it. So if you see inconsistent information, you want to get that in and then you can argue about it in closing arguments. But we'll talk about that next week. Okay. All right, let's get another defense attorney. Who's a defense attorney that wants to talk to me?
I can talk.
Okay. Marie, what do you think is important for your case?
So we're supposed to cast doubt onto the prosecution's evidence, so to like doubt the witnesses that they bring forward.
Okay. So what are you going to use in your case to do that?
Well, what we were thinking of using in our case is to doubt that that the fight happened out of nowhere and that these people were just willing to fight just to fight. We were more so to bring more background into what led up to the altercation.
Okay. So, okay, that's a good theory. How are you going to get that in?
We were going to use their statements because the witnesses' statements because they stated that they had felt something or they had felt something during that day or that something else had happened during that day that led up to the fight, and also to use the witnesses that witnessed the fight.
Okay, good job. That's correct. That's a good way of using your theory and then taking that theory and trying to find a way to get it in. It's a good job, Lee. Thanks. Any other defense attorneys want to bring up their theory? Nobody? Okay, that's fine. All right. Well, we're getting close to the end here. So to wrap up, I want to just talk a little bit about evidence as a whole. This is a very important concept. There's a lot of moving parts to it. But the most important thing that you need to remember is making sure that the evidence that you have is reliable. Because most of the time, just like this mock trial, you're going to get a packet of information, and it's very, very similar and pretty much spot on to what you already got. The only thing that you can do is mostly for the defense attorneys, but really anyone, is you have the ability to contact your witnesses. So what I want you guys to do, if you haven't already started prepping for your cases, is I want you to reach out to your witnesses. And if you're a witness, I want you to read everything and put yourself in the shoes of that witness, but I want you to act naturally. I want you don't need to read off the paper from memory, because I want you guys to practice like it is in real life. Because if I'm a witness and I saw something 6 months ago, I might not be looking at what I said. I might just be going off of my own memory of what happened. So in this case, because you guys the witnesses weren't actually at a fight, read it, not like memorize it word by word, but get kind of the big points down. And then just as you're practicing with with the lawyers, just act naturally. You might not answer the same way every time, which is fine, because in real life, a person wouldn't answer the same way every time. And that's a good practice for the attorneys, because they know what they're trying to get. They have the statements in front of them. They have the police reports in front of them. So I'll give them practice on how to phrase their questions. And that is how you start prepping a witness. And that's what you're going to be talking about next week. So if you start practicing it with your co-counsel and your attorney and your witnesses now, you'll be even better prepared for next week's class. Does everyone kind of understand what I mean by that? Okay, so remember, this is a team effort. You want to make sure that you're working together on that. Are witnesses supposed to answer questions that aren't in the packet? They can. This is, like I said, this is trial, especially mock trials, a little bit about performance too. It's not just here are the facts. You kind of want to discuss everything and practice what you're going to do. So if, I've been a witness, last year I was a witness for the mock trial team, and I read the fact pattern. I kind of got the general gist of it. And then when I went up there, one time I was a little bit of a smart aleck, and the other time I tried to act all shy. And the third time I was, very blunt and direct and short answers. So, play around with it a little bit, have some fun. It gives you a chance to practice with your attorneys. So, yes, if you haven't reached out to your co-counsel and your witnesses by now, do it today, because you guys have about 9 days before you start doing trial. You should be starting to practice already, at least getting your theory down, talking to your witnesses, making sure that, this is what I'm going to ask you. This is what I need you to be prepared for. Use the Discord for voice if you want to do that, or you guys can do your own calling. So that's why we put all those voice chats up, so you guys can start practicing now. Leilani, you should have received your the State versus Ronald Smalls case packet. It's got the police statements and the witness statements, and the citation in there. That's your whole trial right there. So if you haven't gotten that, you need to contact Katya right after class today. Tiani, I wouldn't advise to do that. You can kind of add some details in for some flavor with the witnesses, but if you walk in there and say something completely different than what your witness statements are, you're gonna get impeached. Are we practicing with opposing counsel? You can, if you guys want to run your whole trial together, because you guys only have about 20-25 minutes for trial. You absolutely can practice running the whole trial together. There's nothing wrong with that, especially if you're going to have, especially if some of you guys may run twice, and you may go from prosecution to defense, or you may go from witness to attorney. You know, real life trial teams practice all together at once. They run the whole trial, and they actually do it for timing because their trials are timed as well. So it's not a bad thing to practice with opposing counsel and their witnesses if you can get everybody together. Sophia, I see you unmuted your mic. Do you have a question? That was an accident, I guess. What do you mean is the deal mutually agreed before live trials? Like a plea deal? I don't understand what you mean by the deal. You wanna, if your mic's working, you can unmute and ask me that way. Oh, so for the purposes of this case, there is no deal. You're going to trial. So you won't really be able to negotiate that. If you want to practice it, you can. I mean, there's nothing wrong with that, but at the end of the day, this case will go to trial. So if you want to practice with them just to make it like real life, like, hey, I'm the state, I got a witness, I got a cop, I got this, I got that. You know, you sure you want to go to trial? You can practice, it's fine, but at the end of the day, you are going to end up going to trial. Jana, I think you guys are going to practice sentencing a little bit next week, but at the mock trial, no. All right, so we got about 7 minutes left. Anyone got any questions at all? Last call on questions, and I'll kind of wrap up. All righty, well, what do we learn in 2 classes after mock trial? There are no actual classes after mock trial. There's 4 days worth of trials, so we can give you guys enough time. You'll be getting a mini bar exam after that, but there won't be any, the summer program, the class part of it will be over after the mock trials. That's okay. Yeah, I don't have the schedule in front of me, so.
We just put that there for the day of the exam is turned in, and then also for graduation.
Okay, here we go. I saw there was the bars, how often we delegated cases. It really just depends on when we get cases and how often they come in. So could be once a month, could be once a week, could be once every 2 months. It just depends. The bar exam isn't crazy hard, but it is going to make you use your brain. But don't worry about what you're getting as a grade. It's just to kind of get you to think and show how much you've learned since day one. Because we actually wrote that with, we kind of model them after actual real life bar exam questions. So they are going to be difficult, but you can get every single one of them wrong and it's not going to matter. It's just about learning. So don't worry about the difficulty. Yes, you can use notes. That's actually what your handouts are that we gave you throughout the class, those video handouts. You know, those really aren't, I know Katya has been looking at them as far as, you know, right and wrong, but they're not being graded against you anyway. So that's for you. And then you can take whatever notes you can. It's not like you're going to put you in a proctored room and watch you like a hawk. It's just for your own knowledge. We ask you to not really talk to everybody else, just so everyone can work it out together. Not so much, you know, to anti-cheat or anything. It's just you know, you've learned a lot. Show yourself how much you've learned, type thing. I don't know what schedule you mean, Fabiola, so if you can clarify that. What specifically is our goal for mock trial? Are we supposed to prove our witness innocent? Correct. What will we do if our witness is proven guilty? So if you're the prosecution, your goal is to get a guilty verdict. If you're the defense, you want to get a not guilty verdict. After that, you're going to get some feedback from your judge, and that's it. There's no sentence. There's no, it's not a real case. It's just for you to get a chance to practice. I believe the last day of mock trials is scheduled for the 22nd. There's 4 days of trial if I remember right. And then Michael might be tried in this fact pattern, but it's a different trial. In fact, usually during fight cases, there are 2 separate trials. You just only handle one of them. I have had cases where 2 people were in a fight, and one night, one courtroom's got one person, the other courtroom's got the other person. Opening and closings, I believe, is going to be discussed next week. I don't think there are arch enemies.
Just regular enemies.
Okay. Those are like frenemies. Let me look
Okay,
at
yeah.
I
Frenemies.
kind of just made that up. So let me look at one quick thing, and then I'll close out so you guys aren't here. I'll let Katya answer Jillian's question, and then I'll wrap up.
So when we assign the exam, it'll be over email. We might do, I don't think we'll do a meeting. We're just gonna send you guys the exam and with the instructions, and then you can submit it after that. And then the last day will be the graduation ceremony. Should you pass the exam, but don't worry too much about that. Yeah, but we will have a graduation ceremony at the end of the course. It'll be on Zoom because we are not meeting in person this year. It'll likely be the 31st, yes.
All right, well, to answer the other question, you are going to go over opening and closings next week. So that'll be something that's covered then. Let me look at one quick thing, and then I'll let you guys go. I was trying to get you done a little bit early, but I got wordy. Actually, your homework for this week will be part of it will be making an opening and a closing, and you'll probably practice that during class. Like, you'll actually get to do your opening and closing. Yeah, it's very important that you all know that everybody passes the bar exam. It is just to show you guys how much you've learned. It's to show you, get you guys use all this entire course, other than teaching you the law, is to get your brain working and thinking about things in a legal way. There usually is no one right answer. There are very few things in the law that have a correct answer or a wrong answer. So don't be scared. Don't be nervous. Don't think you're going to fail. You're not. It is just to test your knowledge and to learn. To learn. So yes, you'll have more than one day to complete the exam. So, all right, well, with that, if you guys have any other questions like that, if you want to message me in Discord, that way I'm not keeping everybody. I know some people kind of get antsy to go. Just shoot me a question in Discord. I'll answer it there.
There's no attendance activity. I just took note of who was participating in the participant list.
Okay. So I'm done. So if you guys, I'll stick around if anybody else has any other questions. But as far as attendance wise, if Katya says you're good to go, then you're good to go. So if anyone has any questions or whatever, I'll stick around. You guys can just unmute and talk to me. And I can hang out for a little bit.
Bye. Thanks for class.
Yeah, no problem, man. Thanks for participating.
Yeah.
Wait, should we be emailing you for any questions that we have about our case since you're the senior attorney?
Say that again, Nikki?
Should we be emailing you for any questions we have on the case since you're the senior attorney?
If it's like general questions, I'd like you guys to use a Discord because I want everyone to kind of work together a little bit and help each other.
Oh, okay.
Normally, in real cases, yeah, you'd want to talk to your senior attorney, but because you guys all have all the same case, if one person has a question, there's a good chance that more than one person has that question too. So I kind of want it to be a little bit of a collaborative effort. And if it's like super specific, then one of us can talk to you in private.
All right, sounds good. That makes sense. Have a
Yep, you too. Mia, I saw you raised your hand. Did you have a question?
Oh yes, thank you. I'm sorry. I just had a quick question. I was wondering, after we graduate, are we required to take on cases?
No, you're not. If you don't want to take
okay.
on cases, you don't have to. We obviously encourage it because it's part of the overall program. But if you don't want to, then that's fine.
Okay, thank you.
You're welcome. Kaylee, I saw you had a question.
Yeah, so what do I do if my co-counsel doesn't really participate?
Like, are they not responding to you, or are they just not working with you a lot?
They take a few days to respond and they aren't doing any work. Like, I'm trying to get them to help, but they aren't really.
I would contact your co-counsel, or sorry, contact Katya and let them know, or let her know, excuse me. But I would just like any case that you have a co-counsel, it's always a good bet to know everything, especially since this case isn't super detailed. Because let's just say your co-counsel is working with you and on the day of trial they get super sick. You want to be able to put your whole trial, you want to be able to put the whole trial on yourself. So that's my advice.
So I'm just gonna do like the assignment myself.
Yeah, I'd talk to Katya.
Okay.
You know, but like.
Right, Mike. Yes, Kaylee, speak with Katya, but we encourage you still to reach. Am I still on mute?
No, you're good. We can hear you.
We want you to reach out to your, continue to reach out to your counsel, co-counsel, and then, but yet let Katya know via email, and then we'll also reach out to that individual as well.
Okay, thank you.
Hey, Katya, we also sent out an email. A lot of them are saying that they didn't receive the mock trial packet. One of them I caught today that they're receiving their mock trial information from director at Clark County Law Foundation. So my email must be going to their spam. So we just got to make sure that we send out an email to all of them, just to remind them that we'll send out more information again on Monday, but also to expect them to just send out just a reminder that that they'll be receiving from director instead of you.
Okay.
Go ahead, Caleb. Leilani, you'll be receiving an updated list. If someone who left impacts your team, you'll know. And then go ahead, Caleb, with your question. I cannot hear you. I'll wait for Caleb's question.
Thank you for this lesson. It was really helpful.
Oh, you're welcome. Glad you had fun.
Bye. Have a good day.
You too. All right, you can just type it. Yeah, that's fine. I'll wait. I'll stick around. So for the recording's sake, going back to the impeaching witness, like with a red light, green light example, what do you do if it's your witness that differs from what they said? Well, that is part, so what, like if my witness changes story, that's part of witness prep. So what you want to do is you want to prep your witness, and if something like that happens and they're not 100% sure, they want to minimize the damage. So just kind of just, you know, if they know their fact is 100% right, then have them stick their answer. But like, let's just say it's a red light, green light thing, right? And you know that they may have said something wrong. You want to coach them, like you want to coach them on important facts, number one. Like, so if the red light, green light's a big thing, you want to be like, I need you to remember these things. But you also want to like coach them, like, you know, if you answer something and you're not 100% sure, and you can kind of tell the other attorney is, you know, they hold up a piece of paper and they know it, you know, there might be a reason for that. So, you know, I always tell my witnesses too, if you don't remember something, just say you don't remember. If you don't know, just say you don't know, because it might be that they really don't remember, and they're just saying that because they don't want to say, I don't know, or I don't remember. So that's another important thing for you to say, to prep your witness on. Now, if they get in there and they just flub it, you kind of have to do your own damage control. And I really can't think of a very good way of doing that, because sometimes your witness just tanks. I mean, and sometimes you can do more damage trying to undo it. Like I did have a trial one time where I had a witness and I pre-trialed with her and everything was okay. And then she got up there and just started answering questions like she didn't do any investigation. She didn't do any independent work on her own. She didn't provide any services for you. I'm just sitting there like, oh God, what are you doing? So I tried to dig her out of the hole. I was like, well, did you have any contact with the mom? Like, just to say maybe she didn't give him the stuff because she had no contact. Oh no, I tried every day. And I'm just like, you just have to stop asking questions. Like, you gotta know when to cut your losses. Because that trial, I didn't cut my losses, and I ended up hammering her more than the other defense attorney, because I was so mad that she just went up there and admitted a whole bunch of stuff that she told me she didn't do. And I was like, what are you doing? So sometimes it's just a matter of knowing when to stop. And if you know you can't fix it, just don't try, because it'll just hurt you more than it helps you. So that's really it. The biggest way to avoid that is to prep your witness. Talk to them, meet with them, tell them what your important facts is. If you know you've got like 3 or 4 facts that's the reason you've got that witness on, you want to run them through testimony, run them through, like, practice with them. Like, I'm going to ask you questions now. Don't tell me to take a break. This is just like trial, and you go. And if they try and time out, you're like, you're no time out. You're on the witness stand. I'm asking you a question. So they get used to practicing that and getting used to responding like that. And then if you do that with them and you tell them, these are the 3 or 4 things I actually need you to remember 100% accurate. I mean, if they can't do that, you know, then that's just the luck of the draw with witnesses. That's the only way I can explain it to you. So no problem. You have any other questions, or is that it? All right, cool. Well, thanks for helping participate today. I hope you had a good one.